All right, we are back on the record in the case of the Commonwealth versus Brett Hankison. All counsel are present. Mr. Hankison is present. And Ms. Whaley, are you ready to proceed?
Yes, Your Honor, Commonwealth is ready.
All right, thank you. Mr. Matthews, are you ready to proceed?
We are, Judge.
Are there any motions that need to be made before we get started?
Not on behalf of the defendant.
No, Your Honor.
Is there a motion for separation of witnesses?
Yes.
All right.
Yes, we join.
Obviously, I don't know who your witnesses are, so if you'll just kind of keep an eye as you hear the door open and close to keep your witnesses out of the courtroom until they have testified. All right. I think we're ready to bring the jury in.
Let me have Julie come out just to assist me when the chair raised and then wait place. Julie, let me grab Julie real quick.
Okay.
Make sure everybody's in their right place.
Good morning, ladies and gentlemen. Anything, oh, Anthony, the hearing device, if you could take it over to the first juror.
The hearing device?
Yes.
Volume control.
All right, is there anything to report from our break yesterday? All right, very good. Well, welcome back to Circuit 13, and at this time I do need to place you under oath. So if you would please stand and raise your right hands. Do you swear or affirm that you will impartially try the case between the parties and render a true verdict according to the evidence in the law unless dismissed by the court? All right, thank you. You may be seated. For those of you who have not served on a jury before or have not watched a trial before, let me just lay out for you basically how a trial proceeds. We'll begin with opening statements. Opening statements are not evidence, but they are very important. They give you a map of chronology of the events that occurred in the case. Sometimes witnesses, out of necessity, will need to be called out of order. So that opening statement may help guide you as you listen to the witness's testimony and you know how to fit that testimony into the rest of the case. The first opening statement in the case will be given by the prosecution. They'll lay out the elements of the offenses that have been brought against Mr. Hankison. We'll also give you a summary of the witnesses that they expect to testify, any physical evidence that they may wish to admit during the trial of the case. Then the defense has the opportunity to make an opening statement, but they're not required to. As they said, they have the right to remain silent. They don't have to actually say anything during this trial. Usually opening statements are made by the defense, sometimes at this stage of the trial, sometimes after the Commonwealth's proof is closed, then the defense counsel may make the opening statement so they can reserve it until then, or may not make one at all. And again, the defense counsel's opening statement also is not to be considered as evidence in the case. Once you've heard opening statements in the case, then we will start with the witnesses. And the Commonwealth, the prosecution, will call its witnesses first. It bears the burden of proof, so it begins the trial. We'll call its witnesses first. I'll place the witnesses under oath. The prosecutor will then ask questions of the witnesses, may also then introduce exhibits, evidence through the witnesses. It's important for you to know that when you hear one of the counsel say, Judge, I wish to admit this into evidence, and if I say yes, it is admitted into evidence, then that is an exhibit that will go back with you to the deliberation room once you begin your deliberations. The reason I tell you that is I don't want you to feel like, well, this is going to be my only opportunity to see this exhibit here in the courtroom. If I say that it's admitted into evidence, then it will go back with you to the deliberation room and you'll have all the time that you need to look at that piece of evidence. So if it's a document, I don't want you to feel like I have to write down everything because I'm not going to have the opportunity to see that again. You will. Now, sometimes we have demonstrative evidence, and that will be brought in. Sometimes those are charts or other things. Those will not go back with you to the jury room, and you will not hear the attorneys ask that that be admitted into evidence. So if that is something that you believe is of consequence to you, then you may want to take more notes regarding that that particular piece of information that is given to you. Once the prosecutor finishes questioning the witness, then the defense counsel has the opportunity to cross-examine that witness, ask that witness additional questions, and then they could then go back over to the prosecution to ask further questions, and that can go back and forth a couple of times depending on the significance of the witness or the clarity of the witness's testimony. Once the Commonwealth has called all of its witnesses, then they will rest, and you heard that someone said that yesterday in court, that the Commonwealth will say, Judge, we rest our case, and then it's the defense turn to put on evidence if they so choose, but again, they're certainly not required to. If they do choose to call witnesses, then once they have had an opportunity to question that witness, then it will go over to the prosecutor to cross-examine that witness, and again, the questioning can go back and forth depending on the witnesses who are called to testify. Defense counsel also may introduce evidence through witnesses, and that's the same as when the prosecution introduces evidence through witnesses. So again, just listen to hear if I say that it has been admitted into evidence. Once you have heard all of the witnesses testify who are going to be called in this trial, then it will be time for me to instruct you on the law. And I will give you, each one of you will be given a copy of the instructions. They will be in writing, typed up for you, so that you can read along. The law requires that I read those instructions to you out loud, so I will do so at that point in time, and you can read along with me, and then you'll each have a copy to take back into the deliberation room when you begin your deliberations on the case. After I have instructed you on the law, and the law is what you then apply to the facts that you have heard during the trial. Once I've instructed you on the law, then we'll have closing arguments, closing statements from the attorneys. At that point, the order switches and defense counsel goes first. And the reason for that is, as we said, the burden of proof is on the prosecution in this case, and it remains on the prosecution. And so they have the opportunity for the last word in the case, so they will give the final closing argument. Closing arguments also, like opening statements, are not to be considered as evidence, but they are very important. The attorneys will stress to you the important points that they have heard during the course of the trial, both from the witnesses and from the exhibits that have been admitted into evidence. And they will ask you to take those things into account when you go to deliberate. Of course, it's up to you as jurors to decide what you want to focus on during your deliberations. But I would ask you to be very mindful of the arguments that are made by both the prosecutor and defense counsel in this case. So that is how, and then at that point you will be taken back to the jury room for you to begin your deliberations. And you will deliberate as long as it takes for you to reach a verdict, and a verdict in a criminal case has got to be unanimous. So all 12 of the jurors who are sent back to deliberate, you will all need to agree on the verdict that you have reached. As jurors, it's your duty to determine the facts and to determine those facts from the evidence and the reasonable inferences that arise from that evidence. But in so doing, you are not to engage in guesswork or in speculation. You should not be influenced in any degree by any personal feelings of sympathy for or prejudice against the parties, for they are entitled to your fair and your impartial consideration. It's your special duty as jurors to decide how much credibility you want to give to a witness's testimony. And it's up to you to decide how to judge that credibility. But some things that you might want to take into account when you're judging credibility is that witness's opportunity to observe, that witness's clarity in their recitation of what they have observed when they testify before you. You might want to take into account whether that witness has an interest or not in the case, and in deciding how much credibility to give to that witness's testimony. And you also might want to take into account that witness's testimony in conjunction with all the other testimony that you've heard to see, does this make sense? Does this fit in with the other witnesses who have testified? Those are just some things you might want to keep in mind in determining the credibility of the witnesses. I'll have further instructions for you, as I said, once we have heard all of the evidence in the case. One other thing that I want to address with you is that I'm going to ask that you not have any communication at all with the attorneys, with the parties in the case, even to ask them, where should I go for lunch, or where's a water fountain, where's the closest snack bar. If you have questions of that nature, if you would direct those to the deputy sheriff, he'll be happy to answer those for you, but I'm going to ask you to not have any communication with counsel just to avoid any appearance of impropriety in case someone else should say, well, I wonder what's going on there, that a juror is talking to one of the parties or a juror is talking to one of the attorneys. And I'm also going to instruct the attorneys to have no contact with you, and also Mr. Hankison to have no contact with you as this case proceeds.